This morning, my colleague Flora and I are going to be presenting on ethical dilemmas. I'm Sophie Hood. I'm a partner here at Keker, Van Esten Peters in San Francisco, and I'll turn it over to Flora to introduce herself.
Hi, everyone. Good morning. We're so excited to have you here and to start off the day. I'm Flora Morgan. I'm an associate here at KVP and excited to dig in with you all.
All right. So we have listed out here a selection, at least, of many of the ethical obligations that we all have as attorneys. There are a lot of them, of course. We have ethical obligations to our clients, to the court, to our adversaries, even. And as folks know, there can be conflicts, or perhaps better put, tensions between these ethical obligations. So today, if we pop to the next slide, we are going to go over a number of scenarios. And then there will be a multiple choice quiz. Don't worry, answers are anonymous. We're not keeping track of anything, of course. But if you get the right answer on the multiple choice questions, you'll have the satisfaction of knowing that you know all there is to know about ethics. And if you happen to get a different answer, you'll have the satisfaction of knowing you joined a good CLE because perhaps you learned a bit about ethical obligations and rules this morning. So with that, we're going to dive right into our first scenario.
Okay, so in this first scenario, and you're going to have to get used to doing a little bit of role playing here. Imagine you are defending a class action lawsuit over alleged misrepresented environmental disclosures. During discovery, outside counsel represents to the court that all environmental testing has been produced and discovery is closed. Several weeks later, sort of late in the game, you discover essentially missing environmental data that was not disclosed to the court. And this test shows that there's higher contamination at one site, but it doesn't affect 95% of class claims. So the court has actually already ruled on some key motions, assuming discovery was complete, and opposing counsel hasn't raised any issues around discovery because they also believe that discovery has been completed. And your company does not want to disclose the missing data to the court. So what, if anything, should in-house counsel do about this kind of error? You have four options here. The first is do nothing. The omission is inadvertent and it has minimal impact to the class claims. Disclosing it now would harm your client's position. And yes, please, can we put up the poll? Thank you. So do nothing. This is a non-issue. That's option A. Option B, conduct an internal review to determine exactly how the error happened, figure out what was missed perhaps, and how this material, great, we have the poll up now, how this material it might affect things before deciding to involve the court. Option C is immediately produce the missing data to opposing counsel and let them decide whether to raise it to the court. And option D is to inform outside counsel and decide together whether to disclose the submission to the court, given the potential impact on past rulings and pending issues. So we're going to leave the poll up while I walk through a few more slides. So don't worry, you're going to be able to still continue to consider your answer here. So what's difficult about this scenario is it impacts a few of those ethical obligations to different individuals that Sophie just mentioned a moment ago. The first party that you need to consider your ethical obligations to is the court, of course. And as a lawyer, you must disclose controlling legal authority that's known to you to be directly adverse to the position of your client. That's under California Rules of Professional Conduct 3.3. You also must not make false statements of fact or law to the court. One second here while I move the poll over. You must also ever offer evidence to, you should not offer evidence to the court that you know to be false. But here, we didn't know it was false, or we didn't know we were misrepresenting. This is something that was sort of overlooked and has now become obvious to us. You also have the option to refuse to offer evidence if you have a good basis to do so. At the same time, you have a duty to remediate if there has been an issue in terms of the disclosures to the court. So if you come to know that material evidence offered to the court is false, you shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. So this is something you have to weigh. On the other hand, you have obligations to your client, which we'll get to in a moment here, and you need to ensure that you are abiding by those duties as well, most important of which would be your duty of confidentiality. As we mentioned, you also have duties to opposing parties, to your adversaries. So you cannot unlawfully obstruct another party's access to evidence. You can't destroy or conceal material evidence. There are actually criminal penalties that are associated with doing something like that. And you can't suppress evidence that you have a legal obligation to produce. So in a situation like this, where we're talking about discovery, questions that might come up are, is this something that's privileged? Do we have a legal basis to withhold this information? And if not, then it really is something that you might have to produce in terms of weighing your ethical obligations to your adversary. And of course, you cannot falsify evidence either. And then finally, you have your ethical obligations to your client. And the most important one of these, I think, is to maintain a level of confidentiality. And so the tension that's brought up here is, you know, that the client, which is the company you work for, does not want to disclose this information. And so this is really kind of a hard line. Although the question becomes, is this confidential information? Or if we had realized that this information existed at the time when discovery was still open, is this something that we might have disclosed at that time? It's important to note here as well that remedial measures do not include disclosure of client confidential information. And so that set of considerations around do we disclose or not really squarely intersects with this ethical obligation. So I think we can close the poll out here and reveal that the correct answer is D. I see that we have a kind of distribution of answer choices here. So I'll walk through answers A, B, and C. Answer A is not the right answer here. Well, not the best answer, we should say, because this is the kind of information that seems as though it should have been disclosed in discovery. And so doing nothing, even though this has a minimal impact, could create issues down the line should this information become known to the opposing party or to the court. Option B actually has some good legs to it. I think conducting an internal review is something you could and should do in this situation to understand, is there something wrong with our discovery process, or how we looked at repositories in the process of discovery? How did we miss this information? This is definitely a good instinct. So 36% of you who answered B, I agree that there's some good things here. But ultimately, it's important to escalate this kind of issue, because it really is one of those scenarios where you could be withholding information that your adversary and the court should have access to. And option C, to produce this information to opposing counsel and then let them decide, is probably too much power to put in the hands of your adversary. I think it may be possible and it's probable that you will have some kind of meet and confer over this sort of information, but to disclose it to opposing counsel and then give them the opportunity to either disclose it or not to the court, one, gives them maybe too much influence, and two, it doesn't quite address the issue of the candor to the court. As we have mentioned, the court in this set of facts has already ruled on some of these motions that have to do with discovery. And so it's important to make sure that they are in the loop without, giving that responsibility over to a party outside of your own. And so option D is the best option here, to inform outside counsel. This is a great way to escalate and to make sure that you're thinking through all of the potential risks of keeping this information not disclosed, and also thinking through potential risks of disclosing this kind of information for that 5% of the class claims that it will have impact on. And then also, gives you the opportunity to think through how to raise this with the court in the most tactful way as well. All right, so 53% of you got that answer correct. So we'll move on to the next scenario.
And one more thing on scenario 1, as you'll see, sometimes the multiple choice answers are not mutually exclusive. So for those of you who selected B, as Flora said, that's a good answer too. It would certainly make good sense in this situation to conduct an internal review and figure out what happened. All right, moving on to the second scenario. In this one, you are in-house counsel for a small startup. Perhaps this is familiar to some of you folks. And you're helping the company negotiate a deal to be acquired. And the deal involves equity and non-compete terms for the founders. So one of these founders asks you to explain the deal terms to her. And she also asks if she should sign. So the questions are, who do you represent at that moment? And should you answer the founder's questions? Let's take a look at our potential answers. I won't read these in full since you'll have them in the poll, since you do have them here in the poll. But A is that you represent both the company and the founder, because she's a key stakeholder. So you can explain the terms to her, give her some legal advice, as long as her interests and the company's interests are aligned. B, you represent the company, not the founder. You can explain the terms objectively, but you can't advise her on whether to sign or not, unless the company specifically allows you to represent the founders and there's no conflict of interest. C, you represent the company, but you may advise the founder on whether to sign because she is a company executive and your role includes supporting leadership. D, you represent the company and you should not explain the terms or offer any advice because doing so could create an attorney-client relationship with the founder, violating your duty of loyalty to the company. So we're going to leave up the poll again as we cover a couple relevant points. So the general rule here is one I suspect that everybody knows. And that is that when a lawyer is employed or retained by an organization, they represent that organization. And they represent the organization itself, acting through its duly authorized directors, officers, employees, members, shareholders, or other constituents. And that is true even if, for example, corporate legal's advice affects the principals or the founders or the executives of that company. And it is also true even in the context of potentially a very small, closely held corporation. So if we go to the next slide here. All that said, as is often the case, it is complicated. And an attorney for especially a closely held corporation may owe duties to individual owners with whom he or she or they have had a close interaction. And here, it really depends on the totality of the circumstances. So that includes the size of the company, the kind and the extent of contacts, and the attorney's access to information relating to the individual owner's interests. So it can get a little mushy. Let's go to the next slide, please. What does this mean in practice? Well, as we said at the outset, your client is the company and not the owner. But explaining deal terms to the owner might be okay. Advising the owner on whether or not she should sign may not be, but it really depends upon the circumstances. And as is so often the case, clear communication is critical. So it could be permissible to represent both, but there could be conflicts, and there are a lot of conflicts and consent rules. So clear communication is definitely the way to go here. Let's go to our answers. All right. As expected, y'all did great on this one. 75% of folks selected what we'll call the best answer, which is B. You represent the company, not the founder. You may explain the terms objectively, but you can't advise her straight up on whether or not to sign, unless the company specifically allows you to do so, to represent its founders, and there's no conflict of interest, right? And you would need clear communications about all of that in writing, preferably, right? There's nothing more clear than that. Let's go ahead and move on to our next scenario.
Okay, so scenario 3, you are working, we're talking about working at competitor companies and the ethical rules that come up with that. So you are in-house counsel at a company called Alpha that develops wearable technology. I'm not wearing any, oh, I am actually, like an Oura ring, for example. You're overseeing a patent infringement lawsuit against Beta, which is a competitor of your company, and you are represented by outside counsel law firm LLC. Your boss is the associate general counsel, and she actually previously worked at Beta as an IP attorney. She claims she had very limited involvement with the patent at issue during her time at the competitor company Beta, and that it was over 7 years ago, but may have been in a couple meetings where the patent was discussed. She has been walled off from the case and is not participating in or advising on the litigation. So our question is the conflict of interest that your boss, the AGC, has, is it imputed to you? And can you represent Alpha in this matter? So our options here are, once again, we have 4 of them, and you can see them in the poll. I'll just walk through them briefly. It's essentially yes, no, but for different reasons. So option A is yes, you are conflicted out because your boss has a conflict and she is part of the legal team at Alpha, and you must notify Beta and withdraw from the lawsuit. So done deal, you cannot work on this. Option B is no, the conflict is not imputed to you because your boss is not actively involved in the case and she only had minimum contacts with it back when she was at Beta 7 years ago. And so you can continue representing Alpha. There's no potential conflict. Option C is the conflict is imputed to you because your boss was previously working at Beta, and even that minimal exposure could create material conflict. And also keeping in mind the ethical rules, these ethical rules are related to conflicts of interest that apply to in-house teams, not just law firms. Option D is no, the conflict is not automatically imputed to you, but you should take some additional steps to make sure that a few things are in place to make sure there's no sort of improper sharing of information across screening, and that your boss doesn't actually isn't in any meetings or isn't inadvertently or indirectly giving input on the case. So you can continue representing so long as you do that due diligence. So we'll keep the poll up as we walk through a few of these slides here. So there's a few rules that speak kind of directly to this issue and when conflicts are imputed. So in general, lawyers associated in a firm, and it does use that word here, but this also applies to in-house legal departments and teams. None of those folks who are associated in either the department or the firm shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so. Unless, And there's a few situations in which this is okay. So the first is if the conflict arises out of a personal interest of the prohibited lawyer, not a professional one, and it does not represent a significant risk of limiting the current representation, then the conflict does not impute to the rest of the law firm. Another scenario where the conflict does not spread is the representation is adverse to a former client at the prohibited lawyer's prior firm. So that's sort of the situation we're talking about here. And the prohibited lawyer is not substantially involved in the matter. That person is timely screened from the matter, and written notice is promptly given to the affected former client. So perhaps there's a path to working on this case, even though that your boss was involved in potentially the underlying patent at Beta. So there's a few comments to Rule 1.1, which I think help color this a little bit more because there's a lot of gray in this ethical rule. So to determine if a potential prohibited lawyer's previous participation was in fact substantial, you have to consider that lawyer's level of responsibility, the duration of their participation, and the extent to which the lawyer actually advised or had personal contact with the former client. You can also think about the extent to which the lawyer was exposed to confidential information of the former client, which may be sort of separate from their level of participation. And then the standards for actually disqualifying a lawyer or imputing a conflict include sort of whether there has been a timely screen and at the right moment. So there's a few factors there that we should break down. What is a timely screen and what is a substantial ethical screen? So it's not enough, we should say, to sort of have a process. It's important that the ethical screening process actually does prevent the improper sharing of communication between the individual who has the conflict and the rest of their law firm or their legal department. And in some cases, the ethical screen will be sufficient on its own without actually communicating to the former client. So some of the elements of an effective screen include doing it in a timely manner. So it has to be at the very outset of the matter's inception, not sort of halfway through or later on once information has already been broadly shared amongst the team. The screen lawyer also can't share in fees from the matters at issue. And so this is sort of more relevant maybe to a law firm, but there's ways in which you have to think about this even in terms of an in-house team. If necessary, there should be notice to the affected clients, and there are absolute prohibitions on communications across the screen. So obviously this person cannot have conversations with folks who are working on the matter on any information, and certainly not confidential information. That person should also have limited access to the screened matters file. So if there is a sort of dedicated workspace on digital systems or in the cloud, that person should not be able to access those documents. And then finally, that person's access also needs to be limited in terms of the physical documents and things that might be floating around the office. So ethical screens are actually quite important, and I think we all know that. And unfortunately, even when you do have a screening process, sometimes you can still end up in a situation where information is being shared. And so our takeaways here are just to remember that firm does incorporate corporate legal counsel, and departments within a company are considered the same as a law firm would be outside. Definitely have timely and thorough screening. And then also, California courts have held that there's a rebuttable presumption that a plaintiff's lateral in-house lawyer who formerly worked at the defendant shared that defendant's confidential information with her current in-house peers. So thinking about this is a rebuttable presumption, but that is sort of the status quo, is that there is this sharing of information, even if that's not actually what's happening. There needs to be documentation and evidence and written proof that that information has not been shared and the ethical screens have been complied with. And just to bring this point home even further, we sort of loosely created this scenario based off of an actual case, which is this dynamic 3D geosolutions case from 2015, where the plaintiff attempted to rebut the presumption by asserting that the lateral lawyer had been appropriately screened, and they had evidence showing that that person had been screened. But the court held that the plaintiff actually failed to rebut this presumption because there was evidence that despite the screening process, that lawyer had actually participated in meetings and other actions related to the litigation. And so it's really, really quite important to make sure that those separations are enforced and that folks know what they can and can't have access to when they are screened from a matter. So coming to our poll, we can close it out and see how folks did. The best answer here is option D, which essentially says, do the extra little bit of due diligence to make sure that the ethical screen that is in place is being abided by. So you don't end up in a situation like the one we just discussed. And I'm loving the trend that we are going in here. Every poll, folks are trending more in the direction of the best answer. So that's great. 88% of you got option D. I do see that a few folks also looked at option C, which is the conflict is imputed to you because your boss did work at Beta. And this is true. This is actually accurate in terms of that the conflict could be imputed to you and that you should be wary of it and really take this quite seriously. So I'm happy to see that folks are erring on the side of caution because I think that's a good place to start. But I think, as we see in option D, you can do additional work to make sure that you are actually cleared to work on this. So long as your boss is not, you're not having conversations with her over coffee or in your weekly team meetings about this particular case. All right, we'll go to scenario 4.
All right. So we're shifting gears a little bit now to talk about California lawyers who are working outside of California. So in this scenario, you are a California licensed attorney, but you are working remotely for a tech startup based in Texas. The startup frequently seeks your advice on California-specific legal matters like employment, contract disputes, but they also ask you to review Texas-specific contracts and provide guidance on local regulatory compliance. So you're not licensed to practice law in Texas, but you do feel confident in your ability to research and address the issues that your company asks about. So the questions are you engaging in the unauthorized practice of law, sometimes shortened to UPL, by advising on Texas-specific matters? And second, what steps should you take to comply with California's ethical rule and multi-jurisdictional practice guidelines? So we can put up the poll. Let's take a quick look at our answers here. A, no, you're not engaging in the unauthorized practice of law as long as you clearly disclose that you're only licensed in California and you base your guidance on general legal principles. You can continue to advise on these Texas-specific matters. B, yes, advising on Texas-specific contracts and regulations without being licensed in Texas constitutes the unauthorized practice of law. So you must either obtain a Texas license or refrain from providing legal guidance on those Texas-specific issues. C, not necessarily, but to comply with ethical rules, you should limit your advice to California law and recommend that the company consult Texas licensed counsel for those state-specific matters. You can provide general contract analysis, but you should avoid interpreting Texas-specific statutes or regulations. And finally, D, no, because you're employed by the startup as in-house counsel, and California multi-jurisdictional rules allow in-house attorneys to advise on all legal matters that are relevant to their client. And there are no restrictions on your ability to provide Texas-specific legal guidance as long as you can competently do so. So let's move forward to think through some of the issues at play here. First, needless to say, these location-related ethics questions have gotten far more common and I would say far more complex in the wake of the COVID pandemic. It changed the way we work and the way we practice law. There is a lot more remote work, and there are a lot more California lawyers working for California firms or companies who want to live in and work from other states. For all we know, there are some folks on the Zoom right now who are in another state. So what does this all mean from an ethics perspective? Let's go to the next slide, please. So high level, the California rules of professional conduct provide that if you are a lawyer admitted to practice law in California, you shall not practice law in a jurisdiction where to do so would be in violation of the professional regulations in that jurisdiction. So in this case, we're talking about Texas. And of course, similarly, you should not knowingly assist a person in the unauthorized practice of law in that jurisdiction. So let's go to the next slide, please. Many states have a rule which is quite similar to the ABA model rule on this issue. That's Rule 5.5B. And basically, a lawyer who is not admitted to practice in the jurisdiction shall not, except as authorized by the rules, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law. And second, they shall not hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. So if you take a step back, big picture, you should not represent where you are licensed and where you are not. If you're not licensed to practice in Texas, don't suggest to anyone that you are. Let's go to the next page, please. There, of course, has been further guidance on this, and it has evolved a bit. So in late 2023, the California State Bar issued a formal ethics opinion and recognized that lawyers working remotely may temporarily and even permanently relocate to another state where the lawyer is not licensed. And of course, that committee wasn't in a position to opine formally on the unauthorized practice of law, but they gave the guidance that California licensed lawyers really do need to consult the multi-jurisdictional practice and unauthorized practice of law rules and authorities of the state where they are physically present. In other words, you need to check. Let's go to the next slide, please. So, takeaways. Rules in California, and it's fair to say other states too, do increasingly allow California attorneys to live and work elsewhere while they're practicing law in California. But you really do need to check the local rules for the jurisdiction that you're in and pay attention and follow as these rules develop. So, continue to attend CLEs in the future. I bet we'll be talking about this next year too, and there could be updates. And finally, you might want to consider taking or passing into the local bar just to be safe and to not have to worry about these ethical considerations. So let's close out the poll and see how we did. Here again, looks like 59% of us got C, which was the not necessarily answer, and grappled with the fuzziness and the multiple considerations here. Several folks also selected option A, 20% of you, which was no, as long as you clearly disclose that you're only licensed in California and base your guidance on general legal principles. That is a very solid answer as well. But we would say err on the side of caution when advising on Texas-specific matters if you're not barred in Texas. So really, the only thing that A is missing is check the specific guidelines in Texas. And it may be that it's fine what you're doing. And it may be that even your advice on those Texas-specific matters is general enough. But better safe than sorry. Let's go on to the next scenario.
Okay, so we've made it to lucky number 5, and I think any conversation about ethics in the legal industry today would be remiss without a discussion of artificial intelligence, which is obviously dominating the headlines right now, but also creating quite a bit of gray around ethics and when lawyers can engage with this kind of technology, how they should be engaging with it, and how to do that in a responsible way. So in scenario 5, you are in-house counsel for a small startup that's highly cost conscious. Maybe this is true for some of you in the room. And so this is an organization that's not going to want to spend a ton of money, especially outside with outside counsel on doing a ton of work around research. And so your CEO wants to understand a couple of legal issues around data privacy compliance for a new product launch, and is asking you, as one of the few lawyers within the in-house team, to take a look at it before engaging outside counsel. To save time, because you're very busy, you decide to use a reputable AI chatbot with a deep research function to explore the question. And the chatbot gives you an insightful response, which you assess to be about 90% accurate. There's a few things in there that are not true or not accurate, but by and large, it's a useful answer. And you consider sending this initial research to outside counsel for verification and refinement. So the question is, can you rely on AI tools for preliminary legal research? And what steps should you take to ensure compliance with your ethical obligations if you do so? So we can pull up the poll here and I'll walk through our options. A is no, relying on AI generated legal research is ethically problematic because AI tools can produce inaccurate, misleading results. They hallucinate, we all know that. And you should conduct your own legal research or engage outside counsel on this question without using AI as an intermediary. Option B is no, because AI tools are not designed for legal research and could expose you to ethical risk and your client to embarrassment if you or outside counsel is misinformed about these results. And even if you verify the output from the chatbot, it's not advisable to use AI for this kind of question. Option C is yes, AI can be a really useful research tool as long as you review the output critically before relying on it. There are no ethical concerns. You've done your due diligence, so you may share that AI-generated research with outside counsel for confirmation and without taking additional precautions. And then option D is yes, you can use AI-generated research, but that research should be treated as a starting point, similar to a Google search, and not a final source. You should also independently verify that information using authoritative legal resources and disclose any AI usage to outside counsel when you share this document with them. So we'll keep the poll open and march through a little bit of level setting on AI. A lot has changed in the last couple of years on this topic, and so we're just going to give a little bit of information to make sure everyone in the room is on the same page about what an AI chatbot is and what artificial intelligence is used for at the moment within the legal industry. So an AI chatbot, and many of you may have seen some of the ones that are pictured here on the screen. We've got ChatGPT, we've got Perplexity, we've got Claude. These are applications that are often web-based and can also be used on your phone that create text, images, and other content in response to user prompts. And they're designed to sort of simulate human conversation. So it feels like you're talking to a colleague. They are programmed to be quite helpful and to sound helpful. And they can be used for lots of different types of tasks like brainstorming, research, drafting, and summarizing information. We are now kind of moving beyond generative AI, which is sort of the chatbot tool, into what's called agentic AI. And this is really the frontier of where the technology is moving. At the moment, AI systems can actually do more than just sort of respond to a single prompt. Many of them that have this sort of agentic set of features, they can do things without sort of autonomously, without you prompting them each time. They can execute multi-step tasks. They can actually use tools, like they can, if you give it permission, they can use your email, they can use your desktop, they can access files on your computer to gather information and to take action. I actually recently used one to clean up my really crazy looking desktop on my personal computer, and it did it in like 30 seconds. And these things are iterative, so they can evaluate what they're doing and thinking, and they think about better ways to improve on the task that you give it. And so these agentic AI type tools are sort of going a step further even than the generative AI tools were in the recent past. In terms of how we're seeing this be adopted in the law, in-house counsel are actually seeing large increases in adoption year over year. So this is a screenshot from the ACC, which did a study on how AI is being adopted amongst in-house counsel. And you see from 24 to 25, they're 52%, almost doubling of more than doubling of folks who are actually already using these tools. And then in the subsequent categories, you see that folks are really getting kind of trained up on how they might be able to use these tools if they're not using them already. So many of you in the room may be thinking, oh yeah, we've had these tools for years, or we recently, adopted these tools. And either way, it's important to talk about the ethics of using these tools and how they can be useful to you and not a hindrance. Folks are using them for, as I said, brainstorming, even contract and brief writing and drafting, refining things that have already been written, legal research. These tools are really great at summarization. They can also be very useful for document review and discovery and fact research. But of course, there are risks, and sort of that's why we're here to talk about this. And we're going to run through a few of them. These are not comprehensive, but just a few to be thoughtful about and to be thinking about as you're thinking through this question and maybe applying it to how you use AI in your job today. So the first risk, which I think is very has been in the news and is probably the most widely known, is that these tools are not always accurate. They can hallucinate and make things up. And so in our field, where you may be asking a question about case law or statutes, and you're looking for a precise and correct answer, AI may produce something that sounds really compelling, but in fact is completely incorrect. And so there have been recent examples of this. We did this presentation last year, and there were several examples that are very much the same, but here are two from this year. These have this kind of usage of AI without independently reviewing and checking that citations are correct or that legal information that it gives out is correct, can actually translate to hurting the reputation of your company or your firm, and also to financial issues. This recent opinion from just a few days ago, where a court actually fined lawyers $30,000 for some AI-related fake citations in a briefing. Secondarily, there's confidentiality risks, especially if you decide to use a free version of one of these tools. There aren't as many protections over the information that you put into the tool, and also that information may be used to train the model that is the powerhouse of the tool itself. And so we have to be very careful about entering sensitive client information. So applying this back to the scenario we're discussing, if you're talking about a new product here and maybe you're getting into the specifics of that product, that would be information you really don't want to put into a public or a free version of an AI chatbot. If you have an in-house version or proprietary version, that may be a safer option. There's also privilege concerns, and it remains unclear whether communications with AI tools, even in anticipation of litigation, are protected communications. And we actually got a little bit of insight on this last month from two different courts that are kind of split on the question, one in the criminal context and one in the civil context. This opinion from Judge Rakoff in the Southern District of New York, in the Hempner case, essentially the defendant who was facing charges of fraud had used, I believe it was Claude, to think through a defense strategy for the charges he was facing. And he used that information, which was based in part on information from his lawyers, to have an exchange with his defense team. And he actually supplied that information to his defense team. But Judge Rakoff said this is not information that is considered privileged. It's not work product. And so it was discoverable and could be used in the case. On the other hand, in the civil context, Judge Anthony P. Patty in the Eastern District of Michigan, in this case, Warner v. Gil Barco, in the context of documents that were, I think it was a motion to compel, the plaintiff's documents had been used, it had used generative AI to create documentation in anticipation of litigation. And so Judge Patty said, this is protectable work product. It was developed in anticipation of litigation, and it is not discoverable. Obviously, these are, initial, this is the beginning of the court starting to grapple with this question. And this is on the federal level, could be, completely different in the jurisdictions that you all practice in more frequently, including on the state level. But it's sort of indeterminate how this question is going to be decided. And so that's another thing to think about in terms of risk. And then finally, there's a lot of regulatory uncertainty around how AI is going to be regulated. And that creates some uncertainty around sort of what we can expect and what sort of protections the companies that create these tools that are extremely powerful, whether they're going to require safeguards, they're going to need to have sort of protections built in. And we are seeing this being fought, kind of duked out at the moment. Many states, I think this year, something like 45 states have actually presented bills around AI, and less than 10 have actually signed into law AI bills that are focused around really transparency and creating a compliance framework around what safety within the AI context looks like. And two examples are here on the screen, one here in California with SB 53, and then there's another law that's similar in New York referred to as the RAISE Act. Both of these laws are sort of beginning to start the process of regulating and creating compliance frameworks around artificial intelligence development for frontier labs and models. On the other hand, on the federal side, we've seen a real reluctance to regulate artificial intelligence. And there was a recent executive order that came out in December that essentially signaled that the federal government is wary of the states kind of having the first bite at the apple in terms of regulating AI. And so the purpose of this executive order is actually to investigate what the states have signed into law so far and seek to take action against states through a number of different ways if the federal government disagrees with the regulations that are in place. So this is actively being decided. We will, I'm sure, see more on this year, but it creates sort of more uncertainty for us around, what are these products and how do we use them, and what kind of access would they have to our internal systems if we do use them. In terms of the ethical rules that are implicated, there's quite a few. These are just a few that we think are really noteworthy to mention. First is the duty of competence. You obviously cannot sort of delegate your professional judgment to any kind of technology, including a very intelligent one in the form of AI. A lawyer shall not intentionally, recklessly, or with gross negligence or repeatedly fail to perform legal services with competence. And really, this question of what is competence is sort of what kind of hits at the intersection of using a tool like AI or an AI chatbot to answer a research question. Are you going through the process of sort of understanding it yourself such that you can sort of provide a service on that information or not? The other that is here on the screen is the duty of diligence. So lawyers must protect information related to representation and take steps to prevent unintended disclosure or unauthorized access to that information. So making sure that you really are sort of taking steps to protect information that you are putting into the world, and also making sure that you are exercising your own due diligence on the information that you are sort of relying on and acting upon in the service of the provision of legal services. And then Rule 5.1 and also 5.3 touch on the supervision of other lawyers, and then also the supervision of sort of non-lawyers or the unauthorized practice of law. It's important to make sure that you take those responsibilities very, very seriously. And if you're in a position where you're relying on AI, or perhaps you're working with someone who's relying on AI and not disclosing that, it can become an issue later on, as we've seen in some of these sort of risks coming to fore for lawyers in the world. The California State Bar is also actively involved in trying to provide guidance to lawyers on how to use AI. And there is currently, this set of practical guidance that can be referred to. It is very much a living document, and the the California Bar is in the process of updating it, in fact, because things are moving so quickly with AI. But I just wanted to focus on the sort of first sentence of the second paragraph here, which is generative AI use presents unique challenges. It uses large volumes of data. There are many competing AI models and products. And even for those who create generative AI products, there is a lack of clarity as to how it works. And so we're using, folks are starting to engage with this really impressive technology. We have to remember that even the people who are building this technology do not fully understand how it works. And so that creates a lot of risk that we already know, and also risk that we can't possibly know just yet, because we are sort of in the nascency of this technology being widely adopted. And as I mentioned, there's going to be sort of forthcoming updates this year to this guidance from the California Bar Standing Committee on Professional Responsibility and Conduct. And there are several rules, including some that we discussed today, that are sort of earmarked for update. And I believe everyone is going to get a copy of these slides. And so we've included what the amendments to those rules as proposed are. And the bar is going through a process right now to accept comments on these rules. So if you feel so compelled, more than welcome to provide your feedback. And then I believe there's going to be a vote on these amendments in May. So our takeaways here are: do not put confidential, privileged, or non-public information into chatbots, absent explicit controls, as in certain enterprise accounts. It's just too risky. We're not saying don't do it, but do it carefully. When using AI for legal work, in particular for legal research, do so with caution and definitely verify that information with other means and reputable sources. Exercise caution not to delegate professional judgment to AI, especially as we saw in the scenario where you might be under time constraints or you don't have a lot of time. Make sure that you are still doing your due diligence to ensure that the information that you operate off of is correct. Set policies and conduct trainings within your own organizations, and of course, keep track of developments and guidance because things are changing on a daily basis. So back to our scenario, which we can close out the poll here. And it looks like folks were drawn to what we thought was the best answer, which is option D. Yes, you can use this stuff and you should. It is sort of where we're moving. It is the future of where technology is moving. And it's important to get sort of a competency around using these tools. But again, it is not yet in a place where you can operate believing that this is a final source. And so you should absolutely independently verify and also share with your teams that you're using AI. I think the sort of stigma around using AI is starting to change and shift, and folks are, as we saw, adopting these tools. And so we're seeing more people use them, but it doesn't hurt to let folks know, like, oh, I did this initial research in, Claude or Perplexity or ChatGPT, and I think it's 90% accurate. Outside counsel, can you please, use this as a starting point, as I think it frames the question that we're interested in, helpfully. That is okay, and I think option D really sets you on the right path with that. Okay, so that is all that we have for you all. And with apologies, we haven't left a ton of time, but if folks in the room have questions, Sophie and I are more than happy to answer.
Thank you so